Thank you, Chairman. I want to thank our witnesses for being with us today for long hours. I want to talk about my concern that regulations proposed by SEC Chair Gensler will increase compliance costs and disincentivize private companies from going public. According to a recent CNN article, there were 7,300 publicly traded companies in the United States in 1996, and today there is 4,300. That is a significant decrease. I'm troubled by the SEC's own estimates that this rule we're discussing today will increase costs of being a public company by 21%. Mr. Roisman, in your testimony, you discussed the complexities of considering foreign and state regulatory regimes on top of SEC's proposal. Unfortunately, my home state of California is the only state mandating disclosure of 3 scope emissions. So can you elaborate on that difficulties and the cost that public companies will have to bear to comply with different rules from multiple jurisdictions?
Sure. So I think the SEC makes it clear that undoubtedly costs will rise as a result of this. Even if companies are tracking this information right now, it's very different to track and collect it to be put into an SEC filing, which is subject to a higher litigation or more likely litigation. In terms of Scope 3 or Scope 2 even, there are essentially provisions within the rule that says you need to take into account if you are subject to material sort of regulatory risk because you're disclosing information due to a California law or a European law, and you're going to have to take that into account in making a materiality assessment. I think some of the concerns people are saying, and I think Mr. Wright did a very good job of explaining this, some of these numbers are just not easy to come up with. I'm not in the industry, I'm just a lawyer, but the level of sort of compliance and outside expertise that's going to be needed in order for me to advise clients that what they're doing is sufficient for being able to put this stuff into their SEC filings is high. And even people are doing it right now, I'm not sure they're ready for that.
Thank you. Both Mr. Roisman and Mr. Stebbins, I want to give you an opportunity to respond to a few arguments that those on my colleagues on the other side of the aisle have made throughout the hearing. Specifically, we've been hearing that the SEC's rule is somehow weak or preferred because the California and European requirements extend to Scope 3 emissions and apply to private companies. So first, can you remind us if California should set federal securities policy? And 2, could you explain what the difference is from a litigation risk perspective between complying with European disclosure requirements versus including climate-related information in SEC filings? Either one of you?
I'm guessing I'm going to start. So I think the role of the SEC or Congress is the place to set both federal laws and federal rules. To your question about is there a difference between complying with state and European regulators, there's absolutely a difference. And especially with Europe. What people often forget is there is not the litigation risk for companies in Europe that there is in the United States for putting things in their filings. So I do think companies need to stand behind what they say, but there's a difference between putting something in a voluntary report than it is into your SEC filings.
Okay. Do you want to add to that, Mr. Stebbins, or should we go on? Okay.
I think we should move on.
Thank you. I want to talk about my legislation, the REG Act. Considering the SEC under Chairman Gensler, SEC is failing to assess the aggregate cost of regulations in a proper way. So I introduced HR 7030, the REG Act, to require SEC to consider the cumulative effects of every rulemaking. So I want to ask this question to Professor White. The SEC's cost-benefit analysis notably fails to account for the ways in which rules interconnect. It also fails to assess the aggregate impacts of each new rule with other rules that companies are required to comply with. So would you explain what it is, the concerning that the SEC only why it is concerning that the SEC only considers the cost of the climate rule in isolation?
Yeah, I think it's, thank you for the question. I think it's important to realize that none of these regulations or rules operate in a vacuum. Companies have to make many disclosures to their stakeholders and stockholders through their Form 10-Ks. And so when you analyze a rule in isolation, you might be able to assess that through a cost-benefit analysis, which I wrote at the SEC when I was an economist. And when you put all of those together, if you're looking at 2024, Gensler has said there's many more disclosure rules coming down the line. Human capital, there was
Gentlewoman's
cybersecurity.
time has
So,
expired.
Yes.
Thank you very much. I yield back.